Court's dictation. 5 seconds. Ready, start. The petitioners have approached this court under Article 32 of the Constitution of India. Stop. They call in question sections 3, 4, and 10 of the Insolvency and Bankruptcy Code Amendment Act 2020, hereinafter referred to as the impugned amendments for short. Stop. Section 3 of the impugned amendment amends Section 7 within bracket 1 of the Insolvency and Bankruptcy Code 2016, hereinafter referred to as the Code for Short. Stop. Section 4 of the impugned amendment incorporates an additional explanation in Section 11 of the Code. Stop. Section 10 of the impugned amendment inserts Section 32A in the Code. Stop. A financial creditor, either by itself or jointly with other financial creditors or any other person, on behalf of the financial creditor as may be notified by the central government, may file an application for initiating corporate insolvency resolution process against a corporate debtor before the adjudicating authority when a default has occurred. Stop. For the purposes of this subsection, a default includes a default in respect of a financial debt owed not only to the applicant financial creditor but to any other financial creditor of the corporate debtor. Stop. Para. Provided that for the financial creditors referred to in clauses A and B of the subsection 6A of section 21, an application for initiating corporate insolvency resolution process against the corporate debtor shall be filed jointly by not less than 100 of such creditors in the same class or not less than 10%. Stop. Of the total number of such creditors in the same class, whichever is less. Stop. Provided further that for financial creditors who are allottees under a real estate project, and application for initiating corporate insolvency resolution process against the corporate debtor shall be filed jointly by not less than 100 of such allottees under the same real estate project or not less than 10%. Stop. Of the total number of such allottees under the real estate project, whichever is less. Stop. Provided also that where an application for initiating the corporate insolvency resolution process against a corporate debtor has been filed by a financial creditor referred to in the first and second provisos and has not been admitted by the adjudicating authority before the commencement of the Insolvency and Bankruptcy Code within bracket Amendment Act 2020, such application shall be modified to comply with the requirements of the first or second proviso within 30 days of the commencement of the said act, failing which the application shall be deemed to be withdrawn from its admission. Stop. Over.